for another bench where a case is continued.
Item number 5, B. Uma Devi, Ajit Narayan.
Matter may be taken out tomorrow, advocate letter is appearing tomorrow, he is offered his for the part.
Uma, what is the case?
The case of premature retirement was not made by the HA. The learned single judge has gone into the merits of the case without giving any opportunity of filing counter and suspended the order.
Yes, it's a vacant file, vacant stay.
Your Lordship, it is nothing but we have produced. Learned single judge has directed us to produce the record and marathon arguments have been taken place. After that, that order has been passed.
Item number 6, Gadi Praveen Kumar.
See, what is DSP? The service at C. They want to know. What is it? 2-3-1-4-3-2-9 Ox 2023. Second, normal. What are the last one? 4-3-2-9-2023 and batch. Dated 11-23. You said 4-11. I said 4-11.
Item number 7 is Surinder Reddy.
Yes.
Item number 7 is Surinder Reddy.
2 weeks.
Gopal Krishna Kalanidhi.
Gopal Krishna Kalanidhi is not eligible.
Yes.
Gopal Krishna Kalanidhi is
2 weeks.
Item number 9, Narikant Shinde. 9 and 10, Narikant Shinde.
Yes.
Actually, this is clear made price out of the connected suits. Suits are filed for cancellation of savings executed by respondent number 2 in this in favor of respondent number 5. So I am missing that
You are for the plaintiff or
I'm for the plaintiffs.
then what happened?
The lower court. An injunction filed by the plaintiff seeking to restrain the respondent.
Because this was,
Yes.
who is the other side?
Mr. N. Gangadhar, my learned friend, I saw copies on his.
What is the order for? Still. Okay, but
This is coming first time.
anything must say, what is, counsel for the appellate is permitted to take out 20,000 points, both of it.
Already served notices.
Well, how can you serve without a court order?
These came in,
Then the name is not printed. The name is not printed.
Yeah, that way I take the Honorable 41, his name is printed. CMA 41, arising out of the same.
Okay, whatever it is, post after 2 weeks. Next. Yes.
Item number 11 to 13 on the Supreme Court Chair, Bharati Services Fund. Then Damodar Reddy, Gola Ramakrishnan.
Only to be planted at your. And the business is over today, my lord, because the pressure is number from all the people, my lord. About how many people are there? There is no, we are so popular, sir. We are made popular that. Where are the DPs? Without them, you can't. Where is the advocate general? EP for EP also, but he is also. Where is your senior? He is coming back. We are coming back. Also. Depends on government. Yes, because the day we can be alumni we have met. In fact, it was again only because the learned grammar theory was part of it. Yes.
Item number 14 to 16, MP Suresh Vaidya Chitralekha, Srikanth Kaveri.
Here comes the
Okay.
14.
Okay.
14.
Right, go on.
So if I take up on 15th, my lord, it's coming. No, my literally. Lordship,
Let there is a dialogue.
Lordship, he is retiring. Only the point on the board meeting, Lordship.
First after 2 weeks, like next.
My client is retiring this month. She's like to retire next month. 15th, Lordship.
Or vacancy, result and vacancy, you will get it.
Through my lord, but 1 month we will run over. It's like
17, Keith Teja Kondaviti, the Editor General.
Yes, madam.
Matter because to termination of school assistants, my lord.
We have to do another thing. First after 2 weeks, like.
My lord. 3 weeks, maybe.
No, cannot. What are they? You have recorded, you have nothing.
posted for this number 1.
Next.
18, Chandraya Shankara, Gadi Praveen Kumar.
2 weeks.
Nineteen, N. Praveen Reddy, V. Narasimha Rao. 20, 21 and 22, T. Ratnakar, C. Rutvik Reddy, G. Panchal.
Sports quota.
23, Muthiah 20, P. 24, Muthiah Pritam, People Home.
Ex-serviceman and regulator. First after 2 weeks. Bad words. Next. Since convenient and power to your batsman and to approve. Next.
25 and 26.
You know, everything is we're looking at the case, we are telling you what happened. So, my lord, since the lordship knows it, we are only come so fast, my lord. That's the only hope. Do not, if the court does not know, my lord, we may have to do some extent. Now, we are trying to be your lordship and they'll get it. It's only the question of delivering that judgment, my lord. Therefore, I'm trying to say that Passover could do. That is one of the most toughest part. That's of the provision of that. It's the charm of the provision of that. We argue, but of no use. That is most important in the entire institution. Yes, okay.
25 and 26, Srinivas Rao Madiraju.
Once after 2 weeks, like 1 week. Go.
27, Abdesh Narayan Sangi, Chief for Revenue.
Successfully getting a state culture. Yes, what is the case?
My third respondent was deleted by university. He has to file counter.
First after 2 weeks, like,
And sometimes we are helpless in certain cases.
if there is any, we gave an opportunity for it.
Yes, madam, we are grateful to us.
You must understand.
I have nothing to say.
Twenty-eight, KV Rajesh, Technical Services, Wow.
You passed over.
I'm only hoping at some point the competitor will come.
Yes, what the case?
But the implementation of the orders of the district library. Other, which ruled in my favor, saying that I am eligible and I have the points. So far, they are not appointed. Initially, the AP public service was not paid for. And not so directly the state, paid for it, paid for it. They have also filed a one, and Bokana on their behalf, some person not right.
That's it. It's that people are clear that they do. For implementation of tribunal order.
But I have not said so, when you read the prayer.
It's not that it's implementation of tribunal.
Ultimately, there is a
Ultimately, it's not. Yes. Since the petitioner are seeking implementation of tribunal protection, the matter has to be lifted before a thing is there. And this registry is directed to verify the thing over before a thing is there.
Twenty-nine, Bajpai Anula, Kali Praveen Kumar.
Also, and yeah, I'm taking one story.
What is the case?
Not the night part in transfer. But the other day, not there was a observation from friends. That he will make a representation for the team and from the list. And he also makes a representation for posting property.
That would be better.
Yes, yes.
Right.
And one more aspect.
Yeah.
He was on leave from July. Let that leave as a commuted leave, as a leave for some station. Next, so that they will not treat it as a discontinuation.
With the penny?
AGA. It's people first.
One and it.
Very appearing.
Fifty साल की कर रहे हैं ASG काल रहे हैं Case really we gave someone we are not interfering with the transfer order.
Item number 30, Srinivas Polavarampu.
For the respondent in this matter, madam, they initially the ethics.
I will, my lord, I am for the appellant, my lord. I am permitted to argue online, my lord.
For the society. For the document.
My lord, I am for the appellant, my lord.
What do you want?
My lord, respond number 1 filed IA, my lord, to receive additional documents, my lord. This may be go along with appeal, my lord.
First along with the appeal. Yeah, 1 of 2020 for final year. Next.
Also, it picks up that it because it's a matter of 2.5, most of the members of the society are in the. And they quite may not, therefore, because it's a 2.5, Lordship space, Justice Navin Rogan has fixed up the date of filing, unfortunately, it increases. So that it, most of the members of the society.
Yeah. Yes, what do you say when you will get ready?
My lord, after 2 weeks, my lord.
First after 2 weeks for final year.
Much obliged, my lord.
What's that?
Much of.
31, Kiran Reddy Mallarappu, Shyam S. Agarwal.
First after 2 weeks.
81-year-old.
That's actually 3 days ago, sir. Can we decide who is absent?
Specific performance, but not everything admitted, consideration, execution.
Don't do anything, give me a, indicate the case, is absent of. Collect.
Can you consider the
Please tell us the law, can you do that?
this next week, my lord. Orders are received very much. Like 18 although the application notified in the law. 23 after 5 years.
Next. Yes, first after 2 weeks.
32 and 33, Macha Sai Krishna, J. Tirupati Reddy, P. Nagendra Reddy. Next in the cross of fictional.
If you wanted to withdraw the. Well, stop, you said you get it, sir. You said you're seriously concerned, are you? Very good.
Pertaining to the cross objection to lodging, it is filed with a delay of 7 days after receipt of notice from the Supreme Court.
If you are agree, first file appeal. I mean, I just giving any counter claims. Then you can find cross objections, but here is the case, you are not giving any counter claims. You are also agreed, you are, in fact, you are the person who is really agreed. You should have filed appeal.
Yes, my lordship, but my HPA holder and I were in the.
Just not with the same argument. You go there.
I may be permitted to do that.
What we have, you must argue a case, not read.
Pertaining to the admitting of my cross objection, my lordship, delay may be converted admitted, my lordship. Relating to that, I may.
Like that manner, you agreed by that order, all the court below, agree.
Yes, sir.
You must challenge that by finding independent appeal.
Yes, my lordship. The appeal is pending and during the pending of appeal only I have cross objection, my lordship. I may be permitted for just.
What is not,
I may be permitted to read off.
Fine, on my problem. The second count is will not have paid, but last week you read 41, but that was in their favor, I think.
Yes, ma'am.
Out of 41, rule 27, read.
I filed the cross objection under order 41/22. I may be permitted to read it, my lordship. Only a small margin.
Any respondent who he may not have appealed from any part of the decree cannot only support the decree but may also state that the finding against him in the court below in respect of any issue sought to have been in his favor and may also take any cross objection to the decree which he could have taken by way of appeal. He has filed such objection in the appellate court within 1 month from the date of service or him. On his pleader
Now,
of
first for hearing, this is after 2 weeks, go ahead and withdraw it. Next.
but here,
Whatever it is, let us see.
instead of 2 weeks, 1 week you lot it.
No,
Lordship may admit the cross objection, my lordship.
just 1 minute, but
Next week you lot.
we'll see after 2 weeks.
34, Muralidhar Reddy from
But the declaration of the partition of
Who is your other side?
it's coming.
What is? Front one declare clear what is out. Council for the appellant is permitted to take out notice of reports. How much is the delay?
Is not. Okay. The installment understanding will be gained by interviews.
We thought it was 33. It's 34.
That is my fault.
What is?
Sitting system.
I said notice is for. Maybe 1 of 2023, what is on? 34, let's.
35, KV Shekhar Pulimamudi Shashidhar Reddy. Shashidhar Reddy, Mara is not the that you can find it.
First after 2 weeks, next.
Friday, my lord.
It's in there, while they counter the digits are traffic, and they serve traffic would have.
Next Tuesday then. That's Tuesday.
Next Wednesday.
Next Wednesday.
Thirty-six, Mallu Nathan Reddy, K. Raghumahendra.
Beg to represent the appellant in item 36, my lords. Pursuant to the interim order passed by my lords, my lords, we have already deposited 42 lakhs of the principal amount, my lords. Pursuant to that, my lords, we are filing the memo today. My lords may be pleased to.
To them, in the subject to them depositing.
They have deposited receipts. Yesterday we checked. When you have deposited, madam?
My lords, we have deposited the same on
When you have deposited?
7th November, my lords, yesterday, my lords.
No.
We are filing the memo today, my lords.
Work after 2 weeks. Next week. No.
I'm obliged.
37, Sharad Sanghi, KFD Kumar.
The restaurant has to be tendered around the time of 37. Sure, the requirement is pretty for.
What do you say?
Yes, both of them have to be.
Okay, first around 137 next week, Wednesday. Is the number 137 today?
38. Parshuramula Gupta, Janardhan Reddy Gupta.
This is to be expected to find out.
39, Vakara Sapna Reddy. E. Chinnaya.
Yes. Post after 2 weeks.
40 and 41. Ravikant Shinde and Gangadhar.
Who is your other player? Will not get both after 2 weeks.
There is remaining trade of this position.
Nothing will happen. But next week,
I already take it. I do, but I think it's a problem.
But case number.
Actually, personal officers in item 9, 10 and this.
yes, yes. Also for the particular permitted. Also for the particular permitted to take. Spoiled, post after 2 weeks, 40 particular.
9 and 10 lakhs.
10 already we have planted.
42, Madhyamam Prabhakar Rao.
May please represent appellant.
Worldwide, pursued the industry, post after 2 weeks is not there. It's
43, D. Nagvi, P. Krishna.
post after 2 weeks. Next number.
44, Jupiter Appeals, N. Praveen Reddy.
Council of operating respondent.
Let me know other thing come post after 2 weeks. Next,
There is a delay and there is no state grant in this case.
well, deposit some amount.
Yes, 50%. Usual output.
Control media because how much is the ticket?
But delay is 27 days. The delay representation is 87 days.
Okay. I have 1 of 2023. 44 I have not cut out for the reason stated here. 2 could have cut out. Ordered. It's already controlled. What is?
I consider it. I was told that there was no state. It was that part. For our parent for the part.
44 years. Okay, then we stay of what is called as a. I'll take a moment. Then we stay of the what is called as
Before 2014. Senior civil.
1 minute. Senior civil. You know what? What is called in India OP number. 24 of 14. January 2023. Passed by the senior civil service Narayanpet. Subject to the condition that the abundance deposit 50% of the amount stated as a dedicated by the court within a period of 8 weeks. And the response are required to withdraw the same on such demand. That's good. It's so.
45 D Linda Rao, L.V. Rama Rao.
Thank you. We have got to case of sub-inspector using the motion for a minute before that. What's up the? Now the I expect minute the note will be snapped. Now the I have minute investigated now the very history and the big factors discipline proceeding is using WhatsApp message of how are you, what are you, where are you. Now that is the minute even scope to minute everything on minute says that outside the quantity of carry to that the way the system is now to be listed. Now stoppage of implement with the cumulative effect here and also minute medicine also minute. It's like ever common that the Supreme Court and on the basis of the Supreme Court judgment, central government issued minute where the message can say does not affect the minute.
All the messages are in unique, sir. That's the problem.
Now the message current not be relevant now the using sometimes current on touching of the minute the message will be. It is a storage message. 1%.
That's only one query, sir. This is the purpose of a person who's trainer, who doesn't know a person.
No,
Yes.
Says. Now it is a very prevalence and motivated and. One minute, one minute. Yes. You want the. You demand the mandatory. Examine the case from the point of view that complainant has turned hostile in the inquiry. So let the discipline authority consider that portion of the. There is no what we will not see all those things. We are not say you know what is we are not an appellate authority. Even it is a reference information technology that one you may go and you can reconsider the case by taking into account the fact that the complainant has turned hostile in the inquiry. And children pass out for it. No, you will also try to set aside and remand. Yes. Let us say, and directly need to re-examine the case. Yes. But we take into account the fact that the witness turned hostile. That this court, this topic is quite. Agreed to the orders for the relevant meaning that petition number 24577 of 2022 dated 3/3/2023. Third reading around on to the petition, special confidence of the response. It has been contended with the petitioner that he was initially appointed as a reserve administrator, appellate amount.
Very good, yeah.
These two applications are filed, pay 1 of 2023 the increment. And 2 of 2023 is multiplication. Who is applying DP? Similar notice passed on the last occasion, Mr. Manmohan Reddy appeared, he was taken his records. He considered almost, then he also said he wants to verify the records, that's the reason the matter was urgent on the last occasion. Similar orders were passed. It's not the first time.
Sir, we are not saying anything here. That's what he's saying. What's our next?
But the orders are there, like, and order forms.
Can we convince anyone? It is for them to come. Next.
But it's, there is some urgency, Manoj, the reason
Next Wednesday, right? Next.
10 days.
Next Wednesday. Next. Very good.
C. Raghu, GP for Finance and Planning.
May please your lordship.
In which?
Your lordship, this is,
15th, right?
may I please your lordship.
It is adjourned to 15th, madam. Next.
49 P. Anantarao, GP for Services 1.
First after 2 weeks test. What is this case, DP Garu? 49?
It's not here. Here it is more on surface.
Okay, right.
I'm not the lot of us inside. It's a because the period.
Is he not coming to the court, Narendra?
Yes, ready.
Okay, both after 2.
50, 51 and 52 are adjourned. 53 GP for Services 1. C. Rajshekar Reddy.
Here and here and here and here. This was not that 70% for the rest of year. You are putting here. The way my theory is already mentioned is I will be a.
What is the preference of?
I know about it.
Is it covered, madam?
What?
It is covered. It is covered in your favor.
No.
Covered against you, sir.
Page 27. I know that.
How it is covered in with that point?
30% quota meeting.
Money Kadani, how it is covered?
He wrongly mentioned that he is reporting PA instead of TA.
How it is covered then? These are the. How it is covered?
There is a 30% quota to be. They got the engagement that you got.
Then why didn't you file discrimination if it is covered against you?
Counted by judicial process. Any that he is having the deeds.
You want your discrimination to be dismissed?
There is covered against you.
Which is covered against you?
30% quota is only the
Where is the judgment?
just like calculation. So page 28. Page 28. After weight allow terms of order in state domain of funds are correct.
Both after 2 weeks. Next. Docket them in a covered and number. Next page of the paper. That's been good.
54. Syed Mushtaq Ahmed, GP for Services 1.
2 weeks.
55. H. Sudhakar Rao, Ramchandra Reddy.
2 weeks.
The court has that, court held that the petitioner has enclosed only square heart of the petitioner's plan. Now, not in idea was the square code, idea was
What to do?
their plan. They are taking tax note because now I am thinking not to alienate the property because they have obtained blanket stay. But in the lower court, they have directed to pay profit. That is also states where the hospital court now below more than 2 lakh have been.
What's after 2 weeks? Next.
56 and 57 K Uday Sri Chicken for Agriculture Arvind Kumar Kata.
No petition.
And for the petition, I finally came petitioner Darshan, we are considered and given promotion to the petitioner and unofficial report.
Nothing so wait. And the might be of one year. The current period appearing for the response and on the court. The pendency of the petition, the grievance of the petition has been resolved by the respondents by UFS number. By UFS number. By URT number 492 dated 8/10/2023. And the petitioners were promoted. Petition was promoted. Joint Director of Agriculture. The counsel for the petition has also not disputed about the said being of the same. This court is of the considered. Both these petitions are liable to be dismissed as the grievance of the petitions has been resolved. Accordingly, dismissed. Next.
58 V Rohit, yes, Chandrasekhar.
This matter was compromised. What was pleased to that?
You are for
Parties to appear before the, petition. The parties to appear before the legal services authority.
Then what
appeared. What did he?
yes. When the matter is taken up for hearing, the counsel for the petition as well as respondent inform the court that the issue has been settled between the parties by way of a compromise mode. Where is the memo date?
More dated 18/7/2022.
18/7/2023, and the said compromise also recorded before the State Legal Services Authority. Correct? And report to that extent has been filed by the State Legal Services Authority.
Parties have also been.
1 minute. Observant dated 4/7/2023.
1810.
I thought legal, because legal services and state legal services. See, there is.
And when the compromise was dated 4/7/2023, and the same was also recorded before High Court Legal System Committee, the report dated 18/10/2023. You have to say the petition is accordingly closed with the said. The petition is accordingly closed in terms of the report of the High Court Legal Services Committee dated 18/10/2023. An observation that the parties have compromised. Compromise the case by memo dated 4/7/2020. Accordingly, the petition is closed. All right. Next. What cases was it?
Only one case.
Okay.
Item number 58.
Nine and 60, Chandraya Shankara, K Uday Sri, R Vinod Reddy.
In the purpose of tender rights. Both are between.
Final hearing matter, chapter number 61, V Sudhakar Reddy, GP for appeal.
First of all,
62 is Srinath Sharma Y Ramarao.
ఇది చేసిన స్టాండింగ్ ఉంది మాధురి చక్కటి కాదు రెస్టారెంట్ ఇన్ఫార్మ్ సార్ మేడం get ready for next lecture. He can answer the next what will be the root of the
Secretary S. Shyam Sundar Rao, Vadi Praveen Kumar.
Where is it? Check, we get some clarity or something.
So the application was asking not to have directed any amount, they said they are not ready to pay any amount. And Lordship was wanted to see about the maintenance, what we get with maintenance question.
What Supreme Court judgment is it?
Well, stating that even if not under Article 1, risks are maintainable under 2 conditions. But Supreme Court judgment.
No, it's my judgment. Why you terminated?
On state
Performance.
they say the administrative ground by Lordship, and there was no inquiry on the administrative.
Okay, judgment చెప్పండి ఎన్ని అక్కర్లేదు.
My Lordship, every judgment, I mean, these are the judgments which state, my Lordship, all the statement that even though it is not covered under Article 1, risks are maintainable under 226 of the High Court.
ఎక్కడ ఒకటి చదువు.
My Lordship, the first judgment, my Lordship, is if your Lordship might see second page, first judgment, page number 670.
First judgment అంటే ఏమి?
First, the sets which are given, my Lordship.
We don't know first చదవండి judgment అంటే.
KK Saxena is an international commissioner.
Alright.
The Lordship might see the third page.
Read.
In the below second paragraph, if an authority body can be treated as part of state within the meaning of Article 12 of the Constitution, usually a petition under 226 would be maintainable against such authority of body, enforcement of fundamental right, fundamental and other rights.
This was dealing with what institution?
My Lordship, this was dealing with it.
It's International Commission on Irrigation and Drainage.
Yes, sir.
Was it army school or something? What is that?
It was not army school, my Lordship. But consideration, if not under 12, schools are, schools do fall under the other.
This is a school. In the present case, which was dealt by the Supreme Court is a school.
All right, so this states about Article 12, my Lordship, where.
What is claim? One day.
Yes, sir.
Because 226, any statutory violations also can be looked into. Correct?
Yes, sir.
That is the reason risks are maintainable. One did not be a state within the meaning of Article 12, but still.
Lordship, there are several judgments where.
One judgment we are asking counsel.
Lordship, for the judgments previously which are submitted that Vim Joshi, my Lordship, where it is considered, Supreme Court held that army schools fall under the word called public authority, my Lordship, and considering that Uttarakhand.
That is in respect of that point that yes, Vishaka guideline.
My Lordship, but even though that petitioner is an army school, my Lordship.
Not like that. Vishaka has judgment, now that act has come. Wherever it is a private institution also, wherever there is. 1 minute. Any institution, private or anything, if there is an allegation, there is some issues of that particular act or judgment, then it is maintainable. That is altogether a different aspect. Now, when it comes to service matters, there is a point. There is 1 minute. The judgment to the lead, education, imparting education is a public duty. Risks are maintainable. Atlantic judgment is for us.
My Lordship, yes, sir. Thank you, I got it.
Running as an educational institution is a public duty. Correct? And I know judgment should have youngster.
I submitted the judgment, second judgment where BS Vinci versus Indian Statistical Institute. State, my Lordship, it is not, it's go to the law. That subject, my lordship, it states, merely registering a body under the Society Act 1860 does not ensure such body is going privacy edit of Article 12. A related case point would be considered when BM Mitzi versus Indian Statistical Institute.
Okay, some other army school somewhere, Haryana, Uttar Pradesh, what is it?
They have considered and passed orders under Article 12, which is maintainable under Article 12.
Sir, one minute. It is affiliated to which board? Army school, TVS. Then that's a తీసుకురావాలి argument. అర్థమైందా?
Come to
Page number 51, sir.
come to page 51.
If sleep history చదవండి అక్కడ, chapter 1. 51, 2 లో.
Foundation administration.
మీకు కాదమ్మా. ఇది ఏదో చదివేస్తారు ఏదో. Formation అక్కడికి చదవండి.
Formation and registration of society is statutory requirement to run education.
So it's a statutory requirement. They must get registered with CBSE. అట్లా state, a statutory violation అని అలా రావాలి. అర్థమైంది? Thanks very much.
And aims and objectives, మీరు కూడా చూసి దాని మీద జడ్జ్మెంట్స్ తీసుకున్నాడు.
Running a public institution, educational institution is discharging the public duties, which is maintainable. ఆ లైన్ ఆఫ్ జడ్జ్మెంట్స్ తీసుకుంది.
The set judgment is equivalent to every para and
The army comes under whom? Central, no, state. So for their children, if you are imparting education by registering in a society, you can also bring that encompassing also.
the judgment of PR Rudrani Suprabhu. It's in serial number 4 judgment, para number 22. Number 22. Para number 22.
Wait.
Here again, you may point out that the mandamus cannot be denied on the ground that the duty to be enforced is not imposed by the statute. Commenting on the development of this law profession of municipal states to be enforceable by mandamus, a public duty does not necessarily have to be one imposed by statute. It may be sufficient for the duty to have one being imposed by charter, common law, custom or human point. We share this view. The judicial control over the fast expanding ways of bodies affecting the rights of people should not be put into water-like compartments. It should remain flexible to meet the requirement of variable circumstances. Mandamus is a very wide remedy which must be easily available to reach ingest wherever it is found. Technically, should not come in the way of granting the relief under Article 22. One more judgment by Dr.
One minute, sir. It is affiliated to CBSE. Whether our AP education code, Telangana education code applies or not? Exam section 79.
My lordship, one judgment, my lordship. I submitted serial number 3 judgment, copy to send. Point number 11, para 11.
Yes.
Judicial review is designed to prevent the case of abuse of power and neglect of duty of public authorities. However, under the Constitution, Article 226 is called in such a way that a writ of mandamus could be issued even against a private authority. However, such private authority must be discharging a public function, and decision to be corrected or enforced must be in discharge of a public function. The role of state expand enormously, and attempts have been made to create various agencies.
Which judgment you're referring to?
My lordship, Vinay Limited versus VN Das. Serial number 3 there. Okay, para 11.
Okay, reserve.
What's up?
Did a good job. Let's prepare a small synopsis. When she was appointed and all of the.
And there are several judgments where also where
One judgment is sufficient.
but to a single judgment, that is that several single judgment where it is covered under article 12.
In the synopsis, right?
Yes, ma'am.
In a couple of days.
We have
Here is there okay. Next. Yeah, attained age of superannuation.
my lordship,
We are asking, I don't know if, but
according to their rules of principle, my lordship, still she can be reinstated because one of the clause of the army rules state principle can be extended, this can be extended at the age of
very strict, there is a.
they can be extended until 63, my lords, for principal and vice principal.
Next.
Day Linda Digital Services 1.
The issue which has been made, the covered by the Indian nature, this honorable court and also the output is to court. Now the amount of seniority, the leader category of the that is they counted for the seniority for the purpose of millet promotion to post of serving sector of police. Whether this matter has been considered, which has been approved by the Supreme Court. I filed one of the mysterious petition. Our right now. We are not acting ordinance. This is the order that have been passed in other cases also, but you know, this is what happened with the writer director. Not all those who are promoted or here on who are working on such more than 3 years should be subject to training. And directed to appear at promotion examination after the training period. They qualified at examination, they should promote on regular basis. So
It's covered.
this order they are challenged now. Now that because of this law which has been valid, they are put up in the Indian base, we can give. Because they are not right now allowed the OS subsequently, like that they should be given as promotion to it as regular promotion. Even other principles, now we not share all, instead non bad.
Again, judgment we can cover it.
Yes. No, I find out the meeting,
You don't have. I will find it.
you will not keep order. I go judgment you are ready.
What? This single. Single be taken and single.
Now the division bench order has been followed by your honor.
When the matter is taken up for hearing, the counsel for the petition of the court, with the issue raised in the present petition is clearly covered by the events rendered by judgment by the Indian bench of this honorable court. In the petition number 39606 of 2012 dated 12/3/2013. And accordingly, the present petition also can be disposed of in terms of the said judgment. The counsel for the petition had considered it during the pendency of the petition. Petitioners have retired some service. However, the benefits. However, the notional benefits as it was extended to the to the respondents in petition number 39606 of 2012 dated 12/3/2013 also may be extended to the petitioners. The council appealing for the respondent can learn not repeated about the said right, but council for respondent to inform the court. Now that the petitioners have retired, the same benefit cannot be extended. This court having considered the rival submission made by the party in the children. When the principal is adjudicated by deviation of this honorable court in prediction number 39606 of the 2021 dated 12/3/2013, the present litigation also deserves to be disposed of in terms of said orders passed by division bench, and the petitioners would be entitled for notional benefits as it was extended in the case of response in the above said litigation. With these observations, it taken into account. Your interpretation is dismissed.
We ought to see that.
No, the declaration which was dismissed by division bench was your interpretation.
Yes, the government.
కొంచెం adopted కాదు. అది పైకి ఏమో. The counsel for the petitioner and contained it. Respond petitioners have approached us at administrative tribunal by filing OA number 693 or 53 of 1988, seeking to count the service
Out of seniority.
to count the out of seniority service also for the purpose of fixing what the seniority and also for other promotions. But the tribunal was pleased to dismiss the way by order dated 30th November 2003, whereas the tribunal in identical cases has allowed OA number 8114 of 2010 by order dated 24/2/2012, agreed with the state orders passed by the tribunal in OA number 8114 of 2010. The state has carried the matter before the honorable, before this honorable court by filing petition number 39606 of 2012. And this honorable court was pleased to dismiss the said petitions by orders dated 12/3/2013, confirming the orders passed by the administrative tribunal in OA number 8114 of 2010, dated 24/2/2012. The petitioners are also identically placed as applicants in OA number 8114 of 2010, dated 24/2/2012, which was confirmed by this honorable court in petition number 39606 of 2012, dated 12/3/2013. Therefore, same orders be extended even in favor of the petitioners. And the benefits given to the respondent in petition number 39606 of 2012, dated 12/3/2013, be extended to the petitioners of the same. Correct, చెప్పాలి కదండి డీటెయిల్ గా మీకే ప్రాబ్లం. లింక్ చేస్తారు కదా.
See, my care, Prabhakar, for what?
Yes. GP గారు. Post after two. But changes which are covered in those just based service. But still some effort we made, like home guard matter, out of senior, all the.
So 69. Bhagat Srinivas Rao, D. Jagannath Reddy, Samir V. Gano, Vivek Jain,
Yes.
M. Srikanth Reddy.
This is the G case. I find I for interest. Yes, senior.
So 1967 was tagged around 66, 68, 69.
Yes.
Actually, 67 is not legal, but anyway.
But you are a leading guy.
But I took 67 and then demanded. So 25th September 2014. But for the remand date, last time I had passed on the remand. Immediate remand matters consider the issue afresh on the guidelines as directed by the honorable Supreme. Now, in the meanwhile, what has happened is there were two implead petitions, another three implead petitions came up for consideration. But one is IA 1 of 2015, IA 8 of 2023, and IA 9 of 2000. Well, I expect good sufficiently.
Then what are these repetitions also tagged on to CRP? There are land and
It's a problem. There is no original ownership. That's the low restriction, but part of the same problem.
Object to what other small says. Why don't anybody prepare a small synopsis of your? That would be better. That would be helpful. When do you want? First have to do it.
About the president. But if you should also your back, there is a lot of I say. What should not be kindly see. Should it's open. See, we are not concerned with the bad graphic requisitions or the orders part. In fact, when some of the petition in CRP is concerned, the land graphic case has been decided in our. An issue which arose on the base concerning an occupancy certificate issue, that is subject matter of CRP. The property in the civil petition is also in the same 5 acres 4 acres. This was tagged along with the description. And if covered by dispute submission.
So whatever it is, what?
Synopsis.
Whether they're relevant, irrelevant, all those things, whatever it is, what is the entry, what is the case? Small percent here, that could be.
Synopsis.
What comes it to?
Right.
Okay.
73 Uday Sri, if the home.
To make it active. With regards to against the way or not considering upping in this manner.
What is the case? Case of punishment or? What is the punishment?
Mistake. Because any fines cannot pay by one stage for a period of 1 year.
This one, only for a period of this cumulative. What is the application? That is a very reasonable punishment, really, not it should have been dismissed from service.
Yeah, it's not there.
He is there. Very small punishment. Even case, GM tag and all those things. Pass over or after 2 weeks?
What I suggest really bad.
You must ask your colleague to the youngsters, they were there. Let them at the beginning. These are all waste cases. Here causes likely did not appear. Correct? Allegation of theft of vehicles and all.
So that I am not. Yes, I am convinced that I should.
Get to the youngster, extra removal from the argument, not the senior. Next. Either, see, minutes argue just say some relief we can grant. If you argue, you know.
No, no. No, I did not. I will see to play.
Yes.
71 Sheikh Jilani Basha,
Maybe. Sorry, no problem. Source. Inspired. Pushing the there is reduction of paper 5 times. And there was looking at the opponent.
Inversion was modified to that of reduction by 5 stages.
Yes.
In the stage, stenographer stage.
Like I need some intelligence.
No, is it? Claim to
No, no. One, only one.
argue or argue. Whatever, yeah, is there?
The person to whom appointed, and he has been removed from the service. See, I will go to the allegations that I made.
It's a 50-50 case. We'll see what we are not express any mind. We have heard you, sir. You said.
Okay.
1750 Mahindra dog, are you having Kumar?
First respondent was taking grant of pensionary benefits, by counting his somewhere past service. And the last occasion, the lordship referred to University of Delhi case. But in fact, that was given to the first respondent. In the first instance, though he opted to continue in CPF, when the option was given for the second time, he opted for it. He was given the benefit of GPS. And he continued in the service for a total period of 20 years in the traditional institution. On his retirement in 2004, the entire pensionary benefits were given to him. What he is asking is, he worked in the Ministry of Defense for 12 years, 2 months. Then he worked in the Ministry of Mass Communication for 3 years. The first part was pensional in defense. In second institution,
It is not.
it is
Not pensionable.
it's not pensionable. So the initial applications by him were to pay pro rata pension. He was not asking for continuing his past services. That was considered according to the respondent 1 to 6, and the pro rata pension was sanctioned to him, but he did not avail it. It is still there. The amount was not transferred to Indian Institute of Mass Communication. And Indian Institute of Mass Communication, after he joined the petitioner institution, to the extent of their contribution, they have forwarded that amount to NIR. Except that the period for which he worked in the defense,
It's not passed on to you.
was to me.
Not passed on to you.
Yes, I told Avinash, and he said he will get instructions and argue after 2 weeks.
Who is appealing for Union of India?
Union of India, Pranati Reddy is appearing. Just now I spoke to.
Because rule 26, sir, pension code, that supports your case. First after 2 weeks, so as to enable the Deputy Solicitor General of India to get inspected.
But we have, these four, you, that the inquiry officer has submitted an inquiry report on 23/3/2023. And after nearly more than 4 years, the state was made an attempt to disagree with the findings of inquiry officer's report. That too, based upon the events which took place after submission of inquiry of, after submission of inquiry officer's report. This itself is in violation of principles of natural justice. The state would have disagreed within a reasonable period of time, but it could not have delayed, disagreed with the findings of inquiry officer, more so in a case where the petitioner has retired. This also, this conduct, this action of state is also found wanted.
That's why you got to solve in the order. This much specific, but
We want to be more specific.
Seven more pound question. 75 G. Allah Baksh K. Buchibabu.
Post of release.
76 Palle Nageshwar Rao. Panchayat Raj.
Post of release.
78 Thakuran Banerjee, GP Services 1.
Yes, post of release.
79 Kankadurga Chelboina, GP Services 1.
Post of release.
80 GP Services 1 V. Ravichandran.
Post of release.
81 GP Services 1 D. Balkrishna Rao.
What? The party number different, 81. 81. Another 90. 90. 90. Morning lecture about out of the yeah, no. Different. Next. Oh, madam, to मालूम है शायद इसको दे कर 81 and out of the मालूम judgment issue 1993 same order. Next. Which item, madam? Let that case be called to
82
yeah. Well, that's the two week.
83 to 85 adjourned. 96 V. Maheshwar Reddy, GP Services 1.
Yes. What is it? He said, retired on the 21, 720. What is the relief you are seeking? It's the distributed from post and allocation to the they are also bring in other side. Next.
87 Bhari Praveen Kumar Gola Ramalakshmi.
Post of
98 Kari Praveen Kumar and Kogeshwar Rao.
Yes.
89 B Narasimha Sharma, A Ratna Kumar.
Yes. Narasimha Sharma, password. Where is Anurag and all central government standing for? Next.
91 Kari Praveen Kumar.
What was dismissed? Kumar.
IT2 B Vijay Revenue.
Where is?
Period was treated as see without monetary benefit. That was another challenge. And now that's the doctor in their treating such a period as duty and without monetary benefit. But treating monetary benefit.
Okay, tribunal grants security. Regional fund and regulation. Is for the disciplinary authority to pass an order under 54.
Proceedings and external proceedings are sent types of granted.
What's after 2 weeks, right?
Everything was granted.
Everything was granted. Except the most we given that for FR. Whenever such things are given, only notable benefits given without monetary benefit. It has been done by the driver. Despite that,
Okay,
the next
94 Harina Reddy Somagupta Chikuta Services 1.
what's after 2 weeks?
95 Vivian Sharma, M.V. Ramarao. There are 2 in each.
Yeah.
Petitioner had rendered more than 34 years and 8 months 16 days service melon, but his past service is not calculated towards a pension before that. Only 15 years and 2 months 27 days are calculated. Reason they state in melon, there he has to explain the option between 1980 to 77 itself melon. Fact, pension came into the from 1980.
Certificate towards this. Here is Ramarao. What manner?
Sorry, so the melon is a serious issue, you know, and then just it's a
What job?
asterisk melon, very sorry to state that.
Password. Yes.
96 Chikuta Services 1.
What is the case? Password.
97 PV Krishnaya, she took the services from 98 she took the services from 99 in the June 100 K Devinder, Priya Siddhartha.
Even the
This discussion is. Which of the two states?
101 P Ramchandra Rao, B Lakshmi Prasanna.
Which of the two states?
My lord, this is Ramchandra, my lord. This Ramchandra, appearing through online, my lord, can kindly be permitted.
which case?
101, my lord.
My lord, I am from the side of quarter to morning, we try to attend the two workshop. Then I was that there is a center for the senior council that presented it and I was granted.
Which 42?
42. EMF compared. Maharaj Prabhakar.
Where is your senior? You are a finisher.
No, he is appeared online for action and when he was actually saying it, the next case is called for action.
So are we responsible for that?
Somebody
else, they were saying that, that's why maybe is also not fit. They filed a query version.
If someone came, you have not served the papers on them.
They've already served my action. Last week, again, it came.
It was not served. Papers are served.
Some jealous. That's it, because it was filed on Friday and we
I think there is this kind of disputes also you understand it.
so far they have not served any papers.
Serve it.
Nothing but it's.
Updated on the
There is a sense of absence of it. We have to take up to one of the.
22nd.
We have to take up to one of the. Sense of urgency because.
What is that sense of urgency?
I mean, in a partition group, they are trying to appoint the receiver to.
I'm going to the sense of the, I don't know. I can see that sense of the. Next Monday.
Tomorrow.
That's.
Tomorrow is it okay? First you must serve the papers.
We have already served it, man. So I give one more minute.
What's next Wednesday?
My lord, this is Ramchandra, my lord, item 101.
Not able to hear, can't decide the case is finally reached in the form of virtual, sir.
My lord.
My lord, I am from respondent in the item number 101. Kindly taken up with letter 2 weeks.
Yes.
Lord, I tell you once,
We will not reach.
At 26, sir.
Candidates, my lord, it's page number 9 to
We are talking about annexures.
26.
26, okay.
Annexures.
But that is not page number 9. Maybe because it is not. Right, thank you. Next.
Two sons of the deceased employee
Ah.
are working as APA and KTW are not any incident.
Correct.
On these grounds, my lord.
You have rejected, right? No difficulty. In case of there is no children employed with anywhere, correct? Until we are trying to distinguish your argument. Correct.
On the ground of whether they are in incident condition or not.
Correct.
That page number 9 to 16 for 242 appointment which we have given. Page number 9. That is serial number 1 to.
Malli page number 9 indamma. Why you are going back to page number 9?
See this 26, 242 candidates, the list we have given.
Correct.
Your lordship, studies last chapter for my candidates rejected on basis of the receiving the.
Madam, there is no difficulty in understanding your rejection in respect of 50 candidates. What we are saying is, page number, 1 minute, 1 minute, page number 5, and page number, come back to 6, come back to page number 6. You said 2 assistant engineers were given compassionate appointment as assistant engineers. Furnish the family details of those 2 assistant engineers. What is the amount of pension they are receiving? And why you are not treating them as not forming part of indigent person? And extended that benefit. That's the point.
Given cases, where the fire accident was taken.
అది ఎక్కడ ఉంది? Where are those details? మీరు ఆర్గ్యుమెంట్ చెప్తే కాదు. Where is the proceedings? Fire accident ఎందుకు we have relaxed and ఎక్కడ ఉంది ఆ decision?
That is the they have issued for those two.
Where is that material? You can't argue anything contrary to record. You will say so many things. Why we must believe you? Seeing is believing. Administrative law is for. So what? So what? You are hiding. Correct.
Serial number 114, millet SC. Superintendent engineer. Only one. Serial number 114.
Drawing family, cases of drawing family pension my lord, we have rejected.
And his son was given as sub engineer, 114. Sudarshanam, ex-SC, TPC.
Yes.
Only 50 cases we have rejected on the ground of family pension.
Then those 50 cases are not before us. Right.
Sir, amounts of 52 cases are before your lordship.
Correct.
Your lordship, my kindly see my lord. We permitted to refer the judgment of the Supreme Court.
Please answer this, counsel. Every person who dies, that family will be receiving some pension, no? Can you reject their cases on the ground that their family is receiving pension? You cannot be considered on compassionate appeal.
Judgment if your lordship.
Supreme Court will not answer anything. That is your policy. Correct.
It is the decision of the employer. I may be permitted.
What is the judgment, madam?
Date of Himachal Pradesh.
Date of judgment.
Date of judgment, my lord, is. 16th January 2019.
Have you gone through the latest judgment of 2023 of Justice Krishna Murari and Justice Nagaratna? They have said if there is a policy, you have to abide by the policy. That's all.
Your lordship.
No. This is the latest, 23. State of West Bengal versus Debabrata Tiwari and others. See, I'll just read one paragraph. The existence of a policy issued by the state government is a sine qua non for making appointments on compassionate basis. Why so and so judgments? The appointments must follow the stipulations made in the policy. Anything more you want? That is the latest.
I may be permitted to read few paragraphs of the judgment which the learned single judge has decided upon. Your lordship may guide.
Question of law, madam, please.
In this connection, reference of bills received from the.
Which, where you are reading, madam?
Your lordship, I have filed the judgment as a material paper in my paper. It starts there.
No, just now you said single judge's order you are reading, no?
Filed the judgment at page number 109 of my paper.
Madam, you are following, reading Supreme Court judgment or learned single judge order, extraction of single judge's order?
Extracted only 2 lines. I am reading from the Supreme Court judgment, my lord, a different paragraph. Learned single judge has referred the judgment at page number 23 as third citation.
Okay.
Versus Kumar.
Which paragraph of Supreme Court judgment? Supreme Court judgment, dear madam, you know?
Collection left for lordships a paragraph in
Huh? You have filed along with the writ appeal that judgment? Which page?
page number
109.
109.
Thank you. Step up. Yes.
My lordship paragraph number 9.
Paragraph 9 lo conclusion undama?
Paragraph of the judgment which clarifies the position.
Yes.
Paragraph number 9 is making me consider.
Okay.
Your lordship may guide policy of that level. Subsequent and office memorandum, no.
Para?
At page 117.
Okay. Yes.
Subsequently, an office memorandum dated 4/4/2008 clarified that while considering whether the family of the deceased exercised their imprisonment circumstances, no certificate of any kind is required. The clarification inter alia provided that no independent certificate of any kind is required as per the instructions. Only independent circumstances of the family are required to be looked into. This purpose can be achieved by examining the income of the family. There is no such certificate prepared by the government, nor should independent certificate be demanded from the affected families. Another aspect of the policy which requires mention is the fixation of the income.
We are reading the policy. We are not interested in policy. What is the finding of Supreme Court?
Lordship and posted with regard to, is there any definition for that?
Huh?
This definition is not required.
Hmm. Correct. Where is that finding of Supreme Court? Trying to read paragraphs. Search for paragraphs.
Desist from taking the family patient. Madam, for your kind convenience, may I make one statement? The judgment which I am relying upon now, or which this court is presenting to you, it has taken into consideration Shashi Kumar also, of Dr. Justice Y.V. Chandrachud. This judgment of 2023. After considering that, this judgment is delivered, the paragraph which I read to you now. At least we are aware of that. Shashi Kumar is covered, taken care of in this. Please listen, madam. In this case, there was a query which fell before the Supreme Court about 2 points. I'm only asking you, if you want, you can go through this, just read it and then come back.
No question. No question of. No question about reading, please.
Your your lordships. Assigning the view 60 to paragraph. Considering the view which has been taken by the High Court in PS 31 and Eminent Senior granted that terms of the policy dated 18/1/1990 encourages the grant of employment assistance to the existence of the government servant, where an employee of the state has right, while in service, leaving the family in immediate contact. The submission is that the genesis of the compassionate appointment is that the assistance should be rendered to the family of an employee who dies in order in a case where the family is in immediate need of substance. It is otherwise left in immediate circumstances. The land council submitted that consistent line of authority of this court establishes the principle that there is no right of compassionate appointment, but only an entitlement to be considered in accordance with the prevailing scheme or as the route paid by the employer. The scheme exists in the present case, it was accepted that the policy as subsequently examination. Kindergarten requires that whether the family is in routine circumstances has to be determined by taking into account the assets left behind by the deceased, the income from various sorts of including pensions, and the nature of life.
Madam, 1 minute, madam, 1 minute, madam. 247 candidates you have given compassionate appointment. All those 247 families were receiving family pension, pensionary benefits or not, please answer that.
Yes.
Their issue.
Conditions, my lord, of this judgment. And I read it to you.
What is the legal point? First formulate. First, 1 minute. You can't just read judgments like that. First formulate a legal point, then. Oh. Yeah.
Supreme Court in this case here. Family pension and other assets have to be taken into the consideration.
What is other asset? No, 1 minute. What is other asset in this instant case? Okay, right. Okay, right. Right, read. First answer this for us, for you to press for that judgment. In all 247, whether family pension was paid or not, please answer that. If no on tape, you can argue that. What assets? Family pension. No. In the instant case only, pension is taken into account. So in that 247, no pension was given. Then why you are discriminating? What is the minimum pension? What is the minimum pension? No, madam. In 247, if you were fair, you should have furnished the details of those 247 family members who are receiving what is the quantum of pension they are receiving. That you will not disclose. 1 minute. If you are truthful and faithful, you should have disclosed in respect of 240. That is the reason we asked you to file an affidavit. How many compassionate appointments you have given from 2014 to 2023? With the reasons, 247 candidates cases were considered for compassionate appointment. What is the pension component? Suppose, let us say, 1 minute, madam, we are not yet over. Suppose one family is receiving 50,000 pension. In spite of that, if you consider for compassionate appointment, in respect of this 247, one candidate is also there. Here you reject their cases on the ground that family is receiving 39,000 pension. This amounts to discrimination. Why they will say you are a state, you must. 1 minute, we are entitled to ask. You are a state, you must be fair. What details you have filed? What is the details you have filed except saying 247? What is the family pension that families are receiving? Have we disclosed? And also how many? What is the family pension they are receiving? Okay, now we'll direct. Case is adjourned. 1 minute. Case is adjourned by 2 weeks so as to enable the appellants to furnish the details of 247 candidates who were given compassionate appointment and the details of family pension being received by the deceased family. Post after 2 weeks, and response are directed to produce the original record of 247 candidates without fail. Failing which the officials of the appellants must be present in the court. Right. Arguing half truth, very dangerous. Right, next.
May it please your lordships. Lords, may I request, there is a small note with the chronology of so small book, volume 2, in WP 18683 of 2009 and batch. Because your lordships to follow that for the dates, my lords, it will be easy. Which one? Yes. Judgment. Yes. అది కాదనుకుంటా అట్లా కాదు సన్న బుక్ ఉంటుంది ఇంతే ఉంటుంది మన దగ్గర ఇంకో వాల్యూమ్ లేదా ఇట్లా కుట్టు ఉంటుందంట
So you're trying to from
No.
May I make one suggestion, Milos? Lordship may finish it off and start this because if this starts, this will go on for the whole afternoon. That will take only 5 minutes, I guess. I don't want to keep the DSG waiting.
I'm ready for the scene.
In the meanwhile, they'll pull it out also. We can save on time.
Only before approaching, challenging the transfer order, he did not approach the competent authority, addressing and seeking the grievances. Letting and yes, and let him report wherever is posted. Thereafter, do only my submission.
Whatever you want to say, you.
Obliged.
అది మాకు ఇన్ అకార్డెన్స్ విత్ లా మీకు కాదు. Don't violate everything.
Obliged.
2 weeks అన్నాం కదా, in another 2 months అని పెట్టాం.
The joining date, Milord, in 7/66/7, Milord.
6/7 అని.
Yes, no, 6/7.
The fact that you are saying 6/7 అంటే how malified intention with the fourth respondent. కదా?
Obliged.
Correct. Yes.
Thank you, sir.
Wait, please. Now, this batch of writ petitions assail an order of the DST.
Applications are not referred to, but they will mechanically reject my all the applications.
No, but you must give a specific complaint. You have not given any complaint to the official response. In the except raising in the OA.
There is no material.
Correct, sir. You have not specifically alleged anything to the official respondents in respect of fourth respondent. That
There's the allegation in that malified which here.
correct.
But there should be some material before the competent authority with regard to agreement.
Don't know. 1 minute, not like that, sir. The role of fourth respondent should be attributed in the form of a complaint against fourth respondent to the higher official. Then they'll examine. That's the point. Without
The
that,
contention is there is no procedure for an appeal against the agreement list.
No, there is a Milord, complaint authority is there, Milord, under page number 120 is there, Milord. They have to make up to.
Let my friend.
okay, the Deputy Solicitor General of India has informed the court. 1 minute ఆగండి. అదే ఫిక్స్ చేస్తున్నాం కదండి, ఒక్క నిమిషం ఆగండి. The Deputy Solicitor General of India has informed the court. There is a appeal provision agreed against the inclusion of agreed list. Let the petitioner also prefer an appeal against.
Let them say who is the applicant.
Agreed list, Milord, it is not with the PF, Milord, it is with CVC and Milord,
మీరే అన్నారు కదా ఇప్పుడు అప్పీల్ ఉందని.
appeal is there.
Where?
Whatever is there, you can not make up.
అది ఎక్కడుంది అప్పీల్?
The complaint authority, Milord, chairman, central board, page 173. Yes.
The Deputy Solicitor General of India has informed the
It's
court.
alternative.
If the petitioner is having any grievance for inclusion of his name in the agreed list, then he has a remedy in the form of an appeal to the
Agreed list.
chairman.
Central board. Central board.
A board.
My friend seems to have not read the pointers properly, page 172. That is the transfer order.
Transfer order. Not 170, redress of grievances. Every commissioner agreed by the order transfer.
CVC
Like-
guidelines and government. India guidelines.
Request has a right.
Is there any project transfer?
My friend is transfer.
But yes, sir, with regard to transfer only. Because agreed list may not be prepared by the CBC. Not by the PF.
అదే అడిగారు కదండి, మరి అప్పటి నుంచి మీరు ఉన్నదని చెప్తున్నారు.
No, no, but
మీరే అన్నారు కదా అగ్రీడ్ లిస్ట్ లోకి వెళ్ళి.
since the beginning, Milord, we are telling Milord, we are not instrumental.
జస్ట్ నౌ యూ సెడ్ అగ్రీడ్ లిస్ట్ లోకి వెళ్ళి రెమెడీ అన్నారు కదా.
Agreed list, Milord, whatever the grievance, Milord, for addressing the grievances, Milord, he has a remedy. Before approaching Milord, the CAT, Milord, they have Milord, did not approach the competent authority.
Is
There
it
is
a
alternate
premature
remedy.
transfer? Is it a premature transfer? Because
No.
para 3.1, it says if it is a premature transfer, then the chairman has to be what is the minister, union
Yes.
minister for labor.
Premature, Milord, whatever the grievance.
Premature transfer, quote unquote, agreed list.
Agreed list, yes.
No minutes, paragraph 5.16 at page 179. There should be a justification for.
Milord, he has not challenged the agreed list also.
So they think those things. But I think it's agreed list on a premature transformation issue, your permit can be considered as that particular. Interpretation.
Para 8 రండి సార్. Para 8 of the judgment. 23rd.
5.16, you have to, the justification should be for the.
1 minute.
Transfer. There is a procedure, that procedure is not followed is my specific complaint before your lordship. Sir.
అదే అండి, para 8 of the judgment చదవండి ఒకసారి. Para 8 of the order, page 27, Amma.
Yes, sir.
It is submitted, Chadandi.
It is further submitted by the respondent that the change of assignment from sensitive to non-sensitive post is a routine administrative exercise done by the controlling officers of the respective cadre. In the past, the applicant himself so and so, that will not be issued.
Please read, no, sir.
As per para 3.1 of the transfer policy, for premature transfer, the chairman central board, that is Union Minister of Labor and Employment in the competent authority, and the included order has been issued with the approval of the competent authority. The second position, the transfer is an incident of service and government employer is best that.
So competent authority is the union minister. He'll examine your case.
Page para 5.16 for a moment, you asked me, at page 179. 3.69 is a.
Because the reason is, sir, at page 90,
Yes.
in the counter which has been filed by the Additional Central Provident Fund Commissioner, at para 3, they say, was included in the agreed list by competent authority of the organization, duly following the prescribed procedure in this regard as per the guidelines issued by CVC and Government of India from time to time.
Yes.
So the competent authority here is the Union Minister of Labor. So he has given the premature transfer on the basis of the guidelines of CVC and Government of India from time to time.
Yes.
So he will be the appropriate authority
To examine.
that. That's the only point we are trying to.
The minister has only directed according to them to place me in the agreed list.
Minister is the most powerful, sir. Right.
Now,
Hmm.
my grievance before your lordship is
Hmm.
whether the agreed list procedure has been followed or not. It is admitted.
Okay.
If he is agreed, he has to challenge the agreed list.
1 minute. 1 minute.
Yes.
1 minute. Again, చెప్పినది cover కానియండి. The petitioner shall submit an application seeking fresh posting orders and also for deletion of his name from the aggrieved list on the ground whether the procedure prescribed for inclusion in the aggrieved list is followed or not also will be looked into by the competent authority.
Page 179 also you lord.
Not necessary.
But I am not persuading your lordship that there should be some.
Agreed list now prepared me prior to much.
Next one. I'm sure. Okay, right. Chadwan, next. Yes, we have seen that.
Any order for transfer shall be done by competent authority for written sufficient reason to be recorded in writing.
అదే చెప్పాం కదండి whether it has been అదే whether examine whether the procedure is followed or not. How can we say all those things? It is for you to write. We have recorded your content. Right? They'll examine whether your name was included in the agreed list after following the procedure or not. That's it.
Followed the paragraph 5.
Not necessary. Right, next.
I was not waiting for a formal order to be passed for rejecting my petition.
No, we have not rejected, in fact. We have disposed of. With these observations, writ petition is disposed of. Right.
Well, let him report for the duties, thereafter make it.
Right, next.
Now both respondents got free, unfortunately.
The fact that you are assisting Deputy Solicitor General itself shows all is not well. Correct? You are a private counsel assisting Deputy Solicitor General. What is this? Yes.
Wait, please. Challenge is to an order of the tribunal made on 31/8/2009.
Ma'am. Note. Note. Note लिखे अपन.
ఇదండి ఇప్పుడు చెప్పాం కదా మళ్ళా ఇచ్చేసారు కదా. Yeah. Oh, sirs, that will have everything.
Okay, ठीक है. Just begin, sir. No problem.
Right. Which in turn is to set aside GOMS 28.
Begin the argument right from the beginning.
Yes, ma'am, I'm aware. The challenge, as I said, is to an order of the APAT dated 31/8/2009, which in turn is a challenge to GOMS.
Give us a brief history also so that we can.
Just give me 2 minutes. Which in turn is a challenge to OA GOMS number 28 dated 29/1/2009. Very briefly stated, the facts of the case are that while a notification issued in 2008, I'll give you lordships the dates later on. I'm just giving your lordships a keyhole on what the facts are, and then I'll take your lordships to the matter. Vacancies were announced for the post of D.Ed candidates and B.Ed candidates. In SGT vacancies were announced. Special grade teacher vacancies. Applications were called for. After the applications were called for, the state reserved 30% of these notified seats exclusively for D.Ed qualified people. Meaning that after the game had begun, persons who were qualified to those 30% of posts were disqualified by a consequential reservation. That GO which brought in the consequential reservation of 30% in favor of D.Ed candidates, in other words, disenabling the B.Ed candidates from taking those posts, is under challenge. My lords, the matter went up and down, went to the Supreme Court. There was parallel litigation. D.Ed candidates came, B.Ed candidates came, government came, review petitions were filed. All that is now may not be really so material to the facts of the present case, because finally a division bench of this honorable court dealt with the matter and came to the conclusion that there are n number of vacancies without going into the major controversy, and it would be good enough, if those vacancies are filled up by the candidates who are already before these courts, and those number of vacancies are lying. Interestingly, my lords, after court officer, please sit down. After the matters, while the matters were pending, the Andhra Pradesh government took in all these candidates who were otherwise qualified, but because of the notification were not employed, and gave them temporary appointments in the nature of permanent contract employment. That was also before the division bench when the matter was being heard. Therefore, the controversy was even less brought about, and the learned bench said, there are n number of vacancies, there are n number of candidates. If we now have to examine that GO, which apparently was changing of the rules after the game had begun, we may have to set aside the entire selection, lock, stock, and the court thought it fit. They can hear me clearly, don't worry. Court thought it fit that via media can be arrived at, and all these people will be accommodated. In its apparent wisdom, the state government takes this matter up to the apex court. The apex court says, having found that the GO was wrong, you could not have just accommodated these people, you should have adjudicated it to its logical conclusions. That is why we are back before this honorable court in a remand of the said petitions. The factual background is, my lords, the recruitment to SGT teachers is governed by GOMS number 96, dated 25 July 2005. Your Lordship would find this at page 23. Page 23 of volume 2. That is this volume, is it? Somebody to let me about it. Page 23 of this thin book. The rules begin at page 8, GOMS 96. In exercise, your lordships have that notes?
Page numbers are not telling you.
Page 8, my lords. The smaller book. Volume 2.
Yes.
I'm sorry if the pages are not.
No, no, they are telling.
Yes.
We could not
In-
tally ourselves.
I saw what happened in the earlier matter, so I'm very worried, man. In exercise of the powers conferred by Section 5 and 12 of the AP School Education Teachers and Other Employees Abolition Ordinance, and the government hereby special rules for education subordinate service. In this, my lords, kindly come to page 23. Internal page 23. You'll have headmaster of primary school, after that librarian in state council, and then secondary grade teachers. Must possess intermediate certificate issued by the Board of Intermediate Education AP and DH certificate issued by the Director of Government Examinations AP, or must possess a bachelor's degree and a B.Ed degree or a D.Ed degree. So, the qualifications for the post of a secondary grade teacher would mean you must have passed intermediate, you must have a diploma in education, or you can also have a B.Ed and a D.Ed degree with a B.Ed. Lordship, see, normally if you have had a diploma, the assumption of you, if you have a diploma and you say this is a qualification, the assumption would be that if you have a higher qualification, you can also be considered. But even that assumption rule was not left open. They made it clear that one of the qualifications apart from diploma is a graduation in the said degree. The same thing is for language pundits, my lords. For the purposes of the present repetition, we will eschew all that. My lords, the said rules are being amended from time to time at the time of every time of recruitment. In the instant case, this was done while the GOMS 182 and 183, which your lordship would find at pages 55 of the said book. Your lordship may see the earlier set of rules that I read out to your lordships were made in 2005. Now kindly come to the rules that were made in 2008. If your lordships come to page of the said rules at page 64. Roman 3, secondary grade teacher, multi-purpose intermediate certificate issued by Board of Intermediate, D.Ed certificate issued by so-and-so, or must possess bachelor's degree and B.Ed degree. Understood? Now, again come to page 72.
64 you read just now. 63 or 64?
64, man. It's page 64.
Ah.
Starts at page
Yes, yes, 64.
55 at page 64. And starts at page 72.
So you are relying on this rule.
Yes, these were the rules that were always there.
No, this GO 182 is issued after the notification.
No, these are all prior. These
No,
are
no.
not prior.
No, after. That GO has no application, right?
Yes, 672,000. I beg your pardon. You're right. You're right.
That going to 182 itself is totally incorrect. One should not go. Correct.
Yes.
Next.
Kindly come to page.
Come back to 161. Rule
One more, I'll
49.
show you lordships and I'll go. Kindly come to page 70.
Not necessary that GO has no application for the present case because that was issued after issuance of notification. No?
Correct. So, the lordship will
abandon your,
kindly
abandon your argument in respect of 82, right? 182. Now come back to page 49.
page 49.
That was amended on 6/12 and on the same day notification was issued, right? Come back to that.
Yes. Page
49,
page 49.
not 49. Where is 161 GO?
25.
Page 25, okay.
Yes.
No. 161 ఎక్కడ ఉంది 25 లో లేదు.
Page, bigger volume, volume 1.
Maybe that was the only case which was not available, right? Bigger volume no?
Well, my memory is not as good as yours.
25, right?
Comprehensive, all the documents have been available. 96/2020.
Yes.
Okay. If one
It's 25 minutes.
correct.
In exercise of the powers conferred under 309, etc., come to
Method of recruitment. Page 26.
your lordships will skip all that. School assistant. Come to page 29.
Yes.
P. Secondary grade teachers and equivalent cadres must possess an intermediate certificate issued by Board of Intermediate so-and-so, DH certificate by the Director of Government, or must possess a bachelor's
The
degree.
same thing is repeated
Same
as it is done in 2005.
Yes.
Correct?
Yes.
So 182 has no application.
No, we are only bringing to your lordship's notice.
That is
that
afterwards.
At all points on time, the prescription was the same.
Correct.
The error was not in the changing of the prescription, but was in changing the rule of the game to the extent of excluding 30% of the post from the qualified persons. That is where we are
Including from 70%.
excluded from 30%.
No, 70%.
30% is now reserved only for D.Ed. So we are only entitled to the petitioner.
70 is for, huh?
We are all BED people.
We are all B.Ed,
30% are reserved for,
D.Ed, D.Ed,
70 is for,
for all. For all. So while D.Ed people get 100 posts eligibility, B.Ed people get only 70% eligibility of 70. While they were qualified for all the 100. There was no disqualification that they suffered according to the rules, according to the notification. This is my first argument. Well, I would eschew advisedly now as to what happened to all the litigation that went on from then till now. Suffice it is to say that the judgment dated 31/8/2009 needs to be independently examined, dehorse all the other litigation that went on up and down. The only other thing I would want to point out contextually to your lordships is, one argument was passed tangentially at the last hearing that all this selection is over, selected candidates are not before this court. Therefore, even if your lordships come to the conclusion that it was illegal, your lordships can do little about it. That argument would not find favor, my lords, for two reasons. The first of the two reasons being that the selection letters of all appointments were subject to result of the litigation in this connection. And some of them are before this they chose to come before this honorable court and implead themselves. The rest chose not to implead themselves. They knew, they were aware that their appointments are subject to this list. Therefore, it is not open for anybody to come and say that this list will affect their rights and they are not being heard. This is one. Secondly, your lordships know that courts have said that when your lordships come to a conclusion that a selection process is marred by illegality, individual members of that selection process need not be made parties to the selection, to the list before the court. Now, kindly come to the impugned order passed in the by the tribunal.
One minute, Senior, just.
Yes.
Now that Ranga's principle has been reversed, saying that it's not a good law, will have it any effect on this case? You want?
We don't have any law. We are not on the saying that after the notification, there was vacancies which arose prior to notification. That
No,
law
no,
was
one minute. Rules were amended by GOMS number 28. Correct? So vacancy should be filled up with unamended rule and all those things.
That may not come into picture at all.
But that ultimately.
No, no, let us answer
Govind,
this.
what do you say? Hello? That's what. So unamended, 1 minute. Unamended rules only recruitment should take place. So such a direction cannot be issued now because the Ranga is reversed.
Amendment itself is not.
No, that is. No, but 1 minute. This 28 is an amendment to 161.
Yes.
Now, if a direction mandamus has to be issued, saying that divorce this amendment, you must fill up the post as per the unamended. That direction will.
Qualification that was prevalent at the
But ultimately, principle will same thing, no?
No, Manjushri talks of a situation
No,
where.
Manjushri is a different thing.
No, but let me answer it this way, my lord.
No, don't get panicky. We are just, no, 1 minute. We are just putting a theory so that you can understand it. You can understand in a better way and argue in a better way.
That's what I'm saying. My endeavor is only that, my lord. We are not in panic at any rate. None of us are in panic. The others at the back, maybe we are not.
The fact that 3 senior counsels are just raising that voice and saying that no, in the sense. But ultimately, the direction is to be given. You fill up the post based upon unamended. Then that is only the direction.
As per the notification.
We are not saying that we want back.
No. 28 is an amendment to the rule. 20. And 28. Then.
Yes. We are saying go by the original notification.
That's all.
Without going into?
Without, we are saying go by the original notification.
Because 28, you could not have done it.
But in fact, they have done the reservation withdrawing.
You got
No reservation and throw us out.
In what context?
Now that we are principally reversed.
Which is reverse, what did they say? That's why I say you can change the rules of the game. That is not the issue. Yeah. Lords.
Yes, my lord. Kerala, the one which went from judicial officers, Kerala. There also, my lord, the honorable court did not modify the basic principle. Not yet, not yet. Not yet.
In fact,
That was also hearing was over, reserved, it was reserved. Immediately after the Kerala judicial officers matter, it was heard, my lord. And then it was reserved. My lord, I'd only say this, my lord, whether such a thing is really warranted at all or not may have to be looked into.
Correct. Anything that. ఏమనాలండి వీళ్ళని? No, ma'am, please.
I will also make my submissions. The state government itself has issued a GO saying to follow the rule which was there at the time of notification in 2010. After the selections.
No, your lordship, they literally put the cat among the pigeons. Yes, no, well, that's an open debate is something that we would all three of us like, we would all welcome it, my lords. We don't like benches which are silent and not all fine.
Okay.
We are on one side, I can speak on them. Okay, I'll speak on your behalf. So, 3 or 5 of us are very fair, my lords. I'm speaking on all our behalf. My lords, just to reiterate on that, the argument or the principle of law that you could not have changed, that any one rule of the game is not bad law even to this date. It still continues to be the law of the land. Our contention has been and is that at all points in time, it is not the case of the government even today that the qualifications have changed. It is not their case that these were the qualifications under one GO, these are the qualifications under another GO. Which of these two GOs have to apply is not the challenge at all. On the other hand, at one point in time, the government came up and said, yes, we were wrong. We should have gone by the original GO, which Mr. Vidyasagar was just now referring to your lordships, and he will point it out to your lordships when he argues the matter. Suffice it is to show to your lordships now, let us see how the tribunal deals with the matter, because that is what your lordships are now dealing with. Kindly come to page 59 of volume 1. The judgment begins from page 49. Nomenclature, mentioning of facts that I've already brought to your lordship's notice. Point number 1. Come to page 58. Last paragraph, paragraph 8. In the light of the contentions raised by both parties, the following are the points for consideration. Whether reservation on the basis of educational qualification is not in accordance with the provisions of Article 16 of the Constitution. Whether the amendment made to the rules under 161 by incorporating Rule 7, calling for application for the post of so-and-so is illegal, arbitrary, and whether amendment is liable to be quashed. For DSC 2008, B.Ed as well as D.Ed candidates are eligible to apply. Initially, teachers appointed in the elementary schools used to be recruited with SCC and 2 years TTC. Subsequently, the qualification was made as intermediate and diploma in education, which is also a 2 years course. Thereafter, the government included graduates with B.Ed qualification as eligible. It is an undisputed fact that the educational qualification of B.Ed is different from D.Ed candidates and that they are not equal to each other. Great truism. B.Ed candidates are eligible for posts of SGT teachers and school assistants, while D.Ed candidates are eligible only for SGT. After intermediate, the candidates join D.Ed and undergo training for a period of 2 years, whereas B.Ed candidates undergo training for 9 months. The notification for DSC was issued on 6/12. As per the original notification, the last date for applications was 16/1. The amendment was made on 29/1. On the same day, the government issued the notification extending the receipt of applications to 10/2/2009. The government of AP, as per issued through GOMS 9. Through GOS 96, dated 25/7/2005, as per the said rules, candidates with B.Ed qualifications are also made eligible to hold the post of secondary grade teacher. Being aggrieved by the same, OA 254 and batch were filed, wherein the tribunal elaborately considered the issue whether B.Ed candidates can also be included in the eligibility criteria for SGT posts, and observed that the state government would like to utilize SGT teachers for teaching primary school children. Insofar as upper primary classes 6, 7 are concerned, there is no bar under the NCTE regulation for. Yeah, I'm showing your lordships how they do not consider the matter in detail. Without having. Sadhu? Just show me. I'll just, that OA number, I'll 9172 and batch. August 2009. 9172/2009 and batch. Which paragraph? Which was the paragraph you wanted me to read?
Fantastic.
My lords, I'll just draw your lords' attention to paragraph 40 of the impugned judgment. Yes, then repeat. Well, in the OA, I just wanted to show your lordships one paragraph to show how their mind worked. Because no, look what they say, my lord. Very interesting. The presented petition, my lord. That is WP number 18683 of 2009 and batch. There's an interim direction, page 98. Um, 9th September 2009. What did it say? That will, yes. 2009. The relevant portion your lordship would find at page 111 of book 1. Having regard to the facts and circumstances of the case, we suspend the operation of the proviso to rule so and so, made in GOMS 16 through amendment made in GO so and so, pending disposal of the writ petition. We make it clear that the selection and appointments made, then this was suspended by the apex court. Very next page. Interim stay as prayed for. Then what happened? 113. Then what happened? These appeals were dismissed. By order dated 15/1/2013, 18/9/2009. Suspend. Interim stay, they said. Interim stay. 2009. 396 of 2009. Came to be closed. That your lordship would find at page 127 of volume 2. thinner volume, the thinner one. 127. During the pregnancy of the appeals, an important development has taken place. The National Council for Teacher Education Amendment Act has been enacted. These questions have been referred to the larger bench by so-and-so, have become academic, do not require answer. This position is not disputed. In view of the above, we are satisfied that nothing remains to be decided in these appeals, they are disposed of. 15/1/2013. Come to page 128. Page 128. Just above the quorum of Justice Lodha, Justice Radhakrishnan, and Justice Sudhanshu Jyoti, above that. After that, this writ petition was. It revives minutes because there was an interim stay. The petition went. Yes. No, I was laughing not at the difference, but at the fact that we versus you will arise at some point in time.
Even the statement from AP versus Telangana, now, there is a difference. I said that it would revive, I am saying it may not revive, I may not be correct. Supreme Court order, kindly see, during the pendency of the appeal, an important development has taken place. The National Council for Teacher Education Amendment Act 2011 has been enacted with the Parliament. Having regard to the questions which have been referred to a larger bench by order November 9, 2009, have become academic and do not require any answer. This position is not disputed with the Senior Council for the parties. In view of the above, we are satisfied that nothing remains to be decided in these appeals and they are disposed of accordingly. Kindly see paragraph. However, we observe that is 3 years from today, the vacancies from secondary grade teachers in the state of Andhra Pradesh are notified. The appellant's hearing shall be entitled to apply for the same, and the provision concerning the age and regard to it shall stand relaxed.
My lords, before my friend goes any further, he's reading the wrong order. Correct. Come to 162, my lords. Come to 162. Come to page 162. This is the appeal in our case against our interim order. 162.
Convenience for
Convenience. Yeah.
Inconvenient, it will be too inconvenient to handle it, my lord, in view of the papers.
Well, let's come to page 163. Learned Counsel for the petitioner submits that in our view fairly that in view of the disposal of Civil Appeal 7479 arising out of SLP 27 so and so, nothing remains. Special leave petition is dismissed in terms of the order dated so and so, passed and so and so. In view of the dismissal of the special leave, interlocutory application for intervention does not survive. It is disposed of accordingly.
Since it is dismissed, or is revived.
So the special leave petition is dismissed. ఎక్కడ ఉంది చెప్పండి ఆ పేజ్ అక్కడ ఉందా This is DSC 2008. So the part of the order that Mr. Sanjeev was trying to fairly bring to your lordship's notice was with regards to 2006. And this 2008, in 2008, the SLP stands dismissed.
Now tell us, Sanjeev, 163, still it revised or it doesn't revise? 163. The order which you read is 127 of thin volume is of 2006 DSC, where individuals have approached. 163 is the appeal which, no, this is also individual, I think, sir. Saidulu.
DD candidate. DD candidate.
Huh?
DD candidate.
Okay, you have not preferred SLP. Only DD candidates have preferred SLP and got suspended at High Court's order.
Their stance was the reverse. They issued a GO saying they will go by the earlier notification.
What is it, GO?
VOMS number 27, which your lordship would find at page 115 of the thicker volume. 115. This is what Mr. Vidyasagar was drawing your lordship's attention to. Kindly come to page 115.
28 was rectified in 27. Right?
Yes. Yes.
Read this.
Yes.
Oh.
Government have accorded permission to the Commissioner and the Director to notify vacancies calling for applications in the conduct of examination in the reference first cited, read above, that is GMS 159. In pursuance of the orders, rules have been framed with reference to second above, that is GMS 161. The Commissioner and Director of School have issued notifications under reference 5 cited, that is the notification of 6/12/2008. The SGT posts have not been filled up due to court cases pending in the Supreme Court in the reference 11 cited, that is CA 7479, etc., etc. And also due to notification of excess SGT posts. Government have issued orders appointing a cabinet subcommittee. Skip that. What the cabinet subcommittee says, your lordship may skip. Come to para 5. The government, after careful consideration, approved the recommendations of the subcommittee. In the circumstances stated above, the government hereby permit the Commissioner and Director of School Education to complete the recruitment process to appoint eligible candidates of SGT posts strictly in accordance with the notification issued in reference 5 cited above, and such candidates be initially appointed as apprentice teachers purely on ad hoc basis subject to final orders of the SLP.
No, there is no reference of 28 here.
Yes. No.
That means that government is also not clear, sir. It never said.
They refer to.
No, had they referred to 28, then your understanding maybe there could have been more clarity. Maybe you are right. Maybe you are right.
That is.
But
But they
yes,
here specifically say.
1 minute. 1 minute. Govind, I think you are the author of this GO. What is the stand of this page number 115? Yes, you said you will strictly fill up the post as per original notification. Then you could not have filled up.
Suspended by the tribunal, not by this honorable court.
Again, when
OA was filed. Immediately they sent that man to the tribunal. The tribunal said in view of the interim stay granted by the Supreme Court, the my lord 27 cannot stand.
okay, what is it, OA?
Page 117, your lordship will find. And Raj, the government issues this GO.
Writing with hand is something very refresh it. Memory like function.
My lords.
That is challenged in OA number
2010. Who challenges it? The government challenges it. Please.
OA
15522 of 2010. is filed by the government of Andhra Pradesh.
Initially.
That's what I'm saying. Against the order of the tribunal, is the government that challenges it. I'm not saying government challenged the geo. Delhi, Daulatabad, Daulatabad, Delhi, Delhi, Daulatabad.
That OS suspending is at page number?
That's not there. That we have not filed. Have not.
The
No,
tribunal's
writ petition order is here, page 117.
Then what did High Court do?
High Court confirmed the order of the tribunal.
Interim order.
Yes. Because their argument was.
1 minute, 1 minute.
Should I have sought and been suspended? Yeah. Well, just a small factual backdrop for this. Your Lordship may recall the main litigation by the B.Ed candidates when they lost before the tribunal and that order was suspended by a division bench of our High Court. That was stayed by the Supreme Court. Therefore, this High Court said, in view of the stay granted by the Supreme Court, you could not have done this. That's all. But clearly the stance of the government is, on the basis of a recommendation made to them by a cabinet subcommittee, was that they must go by the earlier geo.
1 minute, sir. Writ petitions are filed against interlocutory order only, or
Interlocutory.
then writ petition is dismissed.
Yes.
What happened to those OAs?
They are pending.
Huh?
They became infectious after issuance of 62.
Huh?
After issuance of GOMS number 62,
Where is
they
it?
all became infectious because 20.
Somebody has to do that formality, no? Last rights.
Last right.
That last right. Anyhow, last night nobody bothered about it.
No, list all those cases on the next date of hearing. Anyhow, it's 4 o'clock. We may not be complete. Give those numbers.
No, he wants a list of those cases. The cases that this was just.
Which are transferred to this court in the form of transferred writ petitions, if at all they are pending.
I'll verify, my lords. I'll give you a lordship. We'll verify and give you a lordship the numbers.
Well, deciding this case, we can also clean up some High Court also.
Sir, I understand. We are all responsible for that. We will do it, my lords. We'll definitely help your lordship.
Then,
Then the government issues GO 62, which your lordship will find at page 139. And because under this GO, the 30% reservation was given effect to, the challenge in the earlier writ petition, as Shiva would point out, had become an infectious or had become a theoretical issue.
right. What is the stand taken in 62?
Come to paragraph 13 of that order, my lords.
Yes.
Come to para 9.
Yes.
And such candidates shall be initially appointed as apprentice teachers on ad hoc basis, etc. The commission come to. Your lordship may see, I'm sorry. The commissioner and director Hyderabad is requested to complete the selection process subject to the outcome of the orders to be passed by the courts. APA 80, High Court, Supreme Court, and orders of the government issued.
No, 1 minute.
Consequences.
SLP is dismissed now.
Yeah.
APAT has become infructuous.
Correct. And our writ is pending.
This will be subject to result of
This writ petition.
this writ petition. This is
Yeah.
para.
And your lordship will also see.
This is para 13. Para 13.
Para 13, may I complete reading it?
Yes, we have done.
You
Understood.
will be obtaining undertaking from the provisionally selected appointed candidates that they will abide by the orders to be passed. So the fear that they are not heard, that they will not be heard, or that this order will affect them.
Sanjeev,
Not arise.
1 minute. Suppose, as per the directions of Supreme Court, we are just examining the case from so many angles, not that we have made up any mind. If Supreme Court remand order has to be followed, then we'll have to go into the merits and maybe we might set aside 28. Once 28 is set aside, thousands of appointments will be set aside. This is an election year. Take a call. That's also a point which has to be looked into, no? Which might create a problem for you. We don't know, but theoretically it is possible. No?
Well, so far as the state of
One minute, right. Theoretically it is possible, no? So that's the reason it's better you get some revised instructions. That's the point. Technically speaking, everything is possible. Writ petitions are liable to be allowed, writ petitions are liable to be dismissed, writ petition is liable to be disposed of. Don't know, anything can happen. But theoretically, if 28 is set aside, nearly to 30 to 40,000 appointments have to go, no? That's the point. And more so, persons who have rendered more than 15 years of service or maybe 16 years of service. Forget about providing employment to these candidates. Suppose if 28 is set aside, all the selections have to be set aside, be it in the state of Andhra Pradesh or be it in the state of Telangana. So entire thing has to be redone, entire selection process has to be redone, subject to the fact whether you have that merit list or not, because notification is of 2008, DSC of 2008, and whether you have that merit list, who might come in, who might not get in, all those things. That's the point, because this is a serious issue. It will have effect of livelihood of so many families. So it's suppose 30,000 appointments into 4, each family 4 individuals. It might run into lakhs also, no? And educational needs of children, so many will be at stake, no? Such an important issue. I think it deserves to be something. I don't know. Instead of, we thought on the last occasion, somehow we were failed in our view legally.
Government has been suggested, he ultimately said people are to pass appropriate.
No, that is right. But somehow our orders were found to be not in accordance with law. But what to do? That's the point. What we thought is unfilled vacancies can be accommodated with these persons, so that was view expressed by correct, but that view was found.
Government went to show that it is not that. Government was not interested in resolving that issue. Government went, not the private individuals. Government challenges university orders. That is the typical behavior of the state.
No, let us not comment anything. It is they are entitled. No, they are entitled to take their own stand.
That the state of Andhra Pradesh has identified the persons who are eligible to be accommodated in the event order is to be satisfied.
Or else one suggestion. I don't know. The way state of Andhra Pradesh has accommodated them in the form of contract permanent teachers. 1 minute, just listen now. Anyhow, even after formation of state also, scores of people are engaging on contract basis. No? So that practice can be, it's not new to you. You are exploiting or whatever term we may call it. So that's right, whether in the form of outsourcing or contract or whatever it is. So petitioners are willing to be, no, 1 minute, 1 minute, you have not yet completed. Petitioners are willing to get exploited by you.
Choice, my lord.
So,
Get our no choosers before mighty government.
And the only time they'll be humble is the next 15-20 days. Yes, yeah.
Our grievance is, now although identified, let's be continued on contract basis on a suspended admission. To that extent, your lordship can resolve that.
I understand your lordship's sense. Because one order was, nobody can verify. That's not the- that's the your lordship.
Persons with 4 marks, my lord, are teaching DED. That's another problem which your lordship may have to look into the broader canvas. Persons with BED, they are not appointed. Persons who have got only 4 marks in the examination, yes, 4.5. I am indeed obliged for that correction, my lord. 4.5% will teach a child who will be the future citizen of India. Persons who have completed BED, they will be on the streets. Is it not really very shocking for a government to come in the teaching policy where right to education is now considered a fundamental right? No, I am only saying, my lord, this also may have to be looked into. I understand, my lord. And I am not. That's true. Because it's also a human problem.
If that option also open, for you to get some.
What are the points?
Once you are not sure, the state goes some action. That's it. From the government angles, litigation. Yes, and the family, nearly 20,000% already of their future we are taking. Again, how many? Yes. The revised presentation and all those provided, we have accurate marks. A workable solution, thereby nobody is agreeing. So what that passing in your not just not true. That's the reason. It's like that. What should not be so hard the appointment of persons who are working from past 17 years. In a case like this, both views are available. There is no difficulty. Person who are educated, they are that's legal. It would amount to unsettling everything, which is sitting. That is the reason. So, I take your lordship's observations. But having regard to, but those seriousness of the observations is when in the form of a judgment, we are not taken appreciated properly. The fact that what is because before that. So now that your lordship said that in a situation where we are standing now, but I don't spell it out. Yes. Your lordship has said that. That is the reason that I wish I could have delayed that judgment. I don't spell it the way the government paid. We are also not spelling.
Left to the government pleader, he would have delayed it to that time.
Having regard to this needs to be escalated to the highest authority. Grant me 4 weeks time that I come back.
Only one person in this hall is intelligent. All others are, you know what. Only one intelligent.
This is the reason that I am saying 4 weeks time.
You're saying you don't want to take the decision? You want the new government to. No, I don't think if there's an order by a court saying come back with a decision, the court will apply. The court will not apply.
It applies because that's manuals. Your lordship said they're suggesting interim order.
Remand order.
Twenty-nine, 1/4 of GOMS number 28.
Your lordships come to page 3. You have the skin of a rhino.
Justice has to be done.
Rhino skin, yak. The mind of a dinosaurus.
Sanjeev, as far as instructions are concerned, I think you can get instructions. Word may not like. When it comes to based upon your instructions, we can dispose of. Provided.
Regard to situation as of now. But your lordship kindly see that all the government bullet employees.
No, 1 minute. Sanjeev, we have commenced the hearing of this case. We'll continue to hear. There's no difficulty. In the interim, we'll also give you an opportunity to get instructions. There is the issue. Whether you get instructions or not, court case has to be decided as per the merits. Provided you get instructions, there should be some, what you call, credit of some making some decision also might favor you. No, if you get instructions, we can abandon hearing and dispose of by way of it, whatever mandamus or whatever it is.
You can't take that this is not work post or telepost.
Correct, sir. On the same analogy, we cannot also stop hearing this case. No, there is a remand from the Supreme Court.
Saying that your lordship defaulting it.
No, just listen. Just listen. What we are just weighing pros and cons. Suppose if we adjudicate the matter on this merits, decision could be we also express. We could dismiss the writ petition. We could allow the writ petition or dispose of the either way. So the consequences we try to.
See my different.
Okay then. Okay. We have understood. We have understood a difficulty. Don't get instructions. It's up to you. Right. Next. Proceed.
So now that the factual aspects are established, my lords.
Take a call, Sanjeev. 30,000 families.
That's reason that I am asking for reasonable time. I asked for 4 weeks, your lordship has said 2 weeks. But I'm not shunking away from getting instructions from the government. The matter requires that offer is open-ended offer. You can get it next week. Okay. But we'll get it to say it. Otherwise, we are not requesting unfortunately. Very well. Yeah, so it's a serious. They are all.
Only 2 local payments.
Look at their age. No, they can't go back. They can't work. That's one of the criteria. That's what we need.
And these persons are also getting from us
Kota, Fume, Babu.
situated in the same village.
Look at them, pardon the please.
Saying that. I put it to the government.
Kin the pardon.
Expedited Okay, we continue.
మధ్యలో దాన్ని రెఫర్ అవ్వాలి. You have this book with you? Volume 2. Taking citations. If citation will tell me. You rendering. Changing the headings. Not obviously, judgments. Only 3 judgments. This is final heading after 15 years. And 1 judgment for each principal. Your conscience is happy.
Yes, sir. Sorry to interrupt. Please.
Malod's, the first argument, as I said, was that this effectively amounts to changing the rule after the game has begun.
Yes.
That this
What are the judgments? Chairman
Yeah,
said?
I'm cut. In fact, my lords, I've relied on about 1, 2, 3, 4 judgments. They are also mentioned in my book, but I will take your lordships through there. The effect of changing of the rules of the game, 2008, 3 SCC, 512,
Manjushri.
and
Manjushri kada?
and 2017 SCC, 538.
2017.
2017 Supreme Court, SCC, 538.
Volume?
SC, I think it's volume 1 only, it's because otherwise the number would have come. Yeah. SCC. I think it's given as SCC online. I've anyway cited it before your lordships. I've given the copy of the judgment.
Page number చెప్పండి sir.
Page number 538 is the original. 538 in my compilation is at page 266.
Thin or big?
266 of my compilation.
Big. Manjushri is also in big.
225.
This is the compilation is page number?
225.
No.
Volume 2.
260.
I'm sorry, volume 1, page 225 and page 266.
What is his case name?
This is one.
Union of India.
Huh?
Suchitra Sethi versus Union of India.
266.
Suchitra?
Suchitra Sethi
Versus?
Union of India.
Right, next. Manjushri, State of Andhra Pradesh.
Manjushri, State of Andhra Pradesh.
Edi?
These are both available in volume 1. In Manjushri, my lords, kindly see
Suchitra
paragraph.
Sethi is single judge, Orissa. Why are you referring to Orissa? Not necessary.
I'm so sorry. One. This really was. Why don't you say that to me? I'm sorry, my lord. I'm really sorry, my lords. Because he said it, I just pointed it out. I'm told the judgment of, and because it said SCC online, I didn't even see that it was an Odisha judgment. But the reason for that judgment being before your lordship is, it contains multiple judgments of the apex court, which I'll take your lordships through later. Kindly first go to Manjushri, my lords. I think that is, I did not understand. This is the second time you're doing this to me. It's not the way we instructors.
Manjushri ఒకటి చాలండి ఇంకా నెక్స్ట్ చెప్పండి.
Paragraphs 27 and 33.
27 and 30.
33.
Right, next.
1 minute.
That is too elementary, sir. Avanika, please, right?
Yeah. The other point that I would raise was, my lords,
You are relying only on Manjushri, right?
Manjushri.
Right, okay. Okay, we'll hear others also.
Just two more judgments, my lords, on other issues, and then let them both out.
Okay.
That a further classification is impermissible. 1995 Supplement 1 SCC. Page 167 at page. Judge Chupitan could show me a signed copy of the judgment. I don't believe it.
A case, Andy.
This is Chairman and Managing Director Singareni Collieries versus M. Ramesh Chandar and others.
The compassionate appointment, ka?
No, it was about reservation for direct recruitment for internal candidates, whether impermissible as such a quota can be fixed only for candidates covered by 16(4). In the absence of a challenge to such a reservation, the instant case selection made on the
First formulate a legal point, then you can rely.
Yeah, the legal point raised here is that a subclassified reservation is impermissible. After holding a common test for direct recruitment, no quota can be created in the common pool for candidates other than those covered by 16(4) of the Constitution. This is the principle laid down.
A judgment emannar, sir.
Chairman and Managing Director Singareni Collieries versus
reported
in 1995, Supplement 1 SCC, page 167. Justice Sawant and Justice N.P. Singh.
Not interested, right? Tell us the paras.
Para 9.
1995, 1 supplementary, 167.
Yeah.
Para 9. Right.
Para 9.
Which
in the book, my lords, it is at page 221.
Right, next.
The next citation is that the changed geo was not published in the,
Amended geo.
Amended geo was not published.
Is not gazetted.
Not gazetted.
Gazetted కాకుండా నంబర్ ఎట్లయితదండి? Gazetted కాకుండా నంబర్ కాదు కదా?
Number అయిన తర్వాత gazette అవుతుంది. They give it a number before they get gazetted.
So it's done, my lord. They give a letter and then send it to the, what is it, garment printing press.
On what basis you are saying it is not gazetted?
Because we never knew about it. It was not in public domain.
No. Have you obtained anything under Right to Information Act? That's the point. Mere.
We raised that issue, my lords, in our pleadings. They have not denied it.
Yes, Govind.
1987, 1 SCC.
Get instructions whether it is published or not, only to meet their argument. Whether you have pleaded or not pleaded, that's, once it is gazetted, that ground falls to ground, right? But get it written instructions or some proof that it is published somewhere in the geo, because you are the government at that point of time, right? Next.
87, 1 SCC 658. That's
yes. Any other counsel?
But I do not want to repeat it. My friend has recorded. One aspect which is relevant is after the orders of the Sample Court, withdrawing the writ petition.
Which
was dismissed, recording that no further order will be passed.
When that has happened?
That's not 8/2/2017. Then the page 1.
8/2/2017.
Page 164.
Dismiss as infructuous.
Recording that no further orders need to be passed in view of the judgment of the Supreme Court. Then we all file a review.
1 minute. with an observation.
The petition can be closed. Recording that interim orders have been complied with and all the posts have been filled up.
1 minute, dismissed with an observation that
Done.
interim orders have been complied.
Yes, ma'am. And the posts were not filled up with the D8 qualified candidates.
Saying that,
Saying, may I just read my
which page?
page 166.
164 or 166?
164 at the end at page 166. Starts at 164.
Yes.
At 166.
Yes, read.
And see middle of the paragraph. In the light of the aforesaid facts, we are of the opinion that the issue raised in these petitions now rendered solely academic. So and so appearing for so and so fairly concede that owing to the interim order granted by this court, the reservation sought to be made in favor of candidates with D8 qualification was not implemented. And all the posts which were covered by this category of reservation were filled up without.
Then what happened? Review, review.
Then we file a review.
Hello.
Because that.
Right.
that review was allowed on 1/2/2021.
Which page? 169.
9.
Right, next.
Then page 338,
Now, these are restored and we are hearing them, right?
page 338. Yes.
What is?
Order.
Yes. What is this order?
339. Having regard, have the land advocate general and the land counsel to the responsibility of the legal to the only mistake. Yes, sir. Last pattern. In view of the mistake pointed out by the land advocate general and that the direct court of.
Okay,
Clarify that it is open for the government to take a policy decision suitable to meet the situations without reference to the above noted portion of the order. So the direction was given. You take pragmatic view and.
page number?
Page 339.
In which case? In which case? There is altogether a different case, sir. That is filed. That review was filed by the government. What is? That has no application, right?
May not be. That is, I can previously.
Yes, understood.
One more, I need to bring to your attention.
Allow us to go home.
Page,
Allow us to go home, sir.
I'll continue.
Tomorrow.
Grateful day.
Get instructions, Sanjeev. We'll continue, but you'll note there.
Yes.
Yes. Any problem?
No, shall I suggest one thing, my lords? Your
Today
lordships may
Wednesday.
hear the,
Today it's Wednesday. Day after tomorrow again, split benches will be there, no? It's not possible.
for his arguments. Let us all finish, my lords.
Very.
Let us all finish. Because we all are a little comparatively freer than he is.
We'll conclude their arguments.
Yes.
Let them conclude that. We have noted down. If Govind wants to go ahead, let him complete his arguments also tomorrow. Any revised instructions you like to get going like in the form, you have absorbed them as a contract. You want to continue them as contract or regularize or something, some stand, make it clear so that because majority of
Yes.
issues. But we may not also permit him to, in view of the Supreme Court judgment, that contract also will have to go now. Because entire, everything would go.
What would go, you have to be deciding, like, that's saying either way, Ultimately, your lord has, I have.
The exercise done by Govind also has to go in your Supreme Court.
My lords, your lordships can always say that so far as the state of Andhra Pradesh is concerned, they are happy in ensuring that everybody is employed.
No, but
They don't want, they are not behaving
one
like
minute,
Sri
sir, 1 minute, senior. Now that Supreme Court has set aside my order, saying that you decide
No,
whether
that is
28
why-
applies or not.
That is why, if your lordship may see,
If 28
No,
is
no.
decided, contract will go, regular will go, everybody will go. Everybody will go.
May not go.
may not, my lords, we'll show it to your lordships tomorrow.
You be senior counsels could not sustain my order before the Supreme Court. And
No, we were not there. We were not there, my lords.